1, 2, 3. Hello. Oh, I'm on the other side. I'm usually on the. Well, hi. Welcome to the channel. Welcome to a show. I'm Sandra Roman, real estate agent with Keller Williams, and I'm here with my friend Denise. Hi, Denise.
Hello there. How you doing?
And this is episode number 2 of season number 4. We're all about love this season.
That's right. We have a theme for this season, and it's love.
And
oh wait, I'm getting an echo. Hold on.
yeah, because you have your volume.
I have it on Facebook. Yes. So our theme for this season is love. So we're going with different subjects, still bringing you some great resources that you can use and share and have good information. And it's all based on love this season.
Hi, Jean.
Hi, Jean.
Thank you for being here.
Yes.
And Denise, where can they find you? Hi, Kathy.
Hi. These are our loyal fans, Jean and Kathy. Where's Sue? She's always here.
I know. Groupies, where are them?
So yeah, you guys know you can find me on Facebook, Instagram, LinkedIn, or you could just come say hi to me. I live right here in Hop Hog. I'm having a cup of tea. We can have tea together.
And you can find me on Instagram, Facebook, YouTube, everywhere as Sandra Roman Real Estate. And remember, we are live today on Facebook, on Denise's page, on mine, and YouTube. Comment, share, and follow us in all our channels. And today we have a very special guest. Who is our special guest, Denise?
So today we have Christine Scheibler.
Let me share something.
Okay, so
yeah.
Because I always get these names. So she's with a group, the Futterman, Lanzarone, and Pasculi. I think I said that right. Yeah. Attorney group and they specialize in elder law. So it's great that we have her here, and she's going to talk about what to do with your loved one, or how to protect your loved one in a medical crisis, which is some great information. Hi, Christine.
Hi.
Good evening. How are you? Thank you, Denise and Sandra, for having me on today.
Welcome to our crazy channel.
So tell us a little bit about yourself first, and then you can dive right in.
Okay, so my name is Christine Scheibler, and I'm an attorney with Futterman, Lanza, and Pasculi. We have offices in Smithtown, Garden City, and Bayshore. We are a wide elder law and estate planning firm. We handle all levels of estate planning, estate tax planning, long-term care planning. We do handle Medicaid applications for our seniors in need of services. We handle probate and administration of wills and trusts. And we do handle estate litigation and guardianships. So we have hopefully full service for your needs for estate and long-term care planning for you and your loved ones.
Great. That's great. Okay.
Where can they find you? A phone number or something?
So our number is 631-979-4300. That you can use that number to reach all of our offices. We have one central phone system thanks to modern technology. So when you call one of our numbers, you get all of us. Okay.
Hey, that's good.
And yes, and you can find us on the web at www.trustedattorneys.com.
Okay.
Put it on the chat.
Yeah.
Denise always writes everything on the chat.
I'm trying. She said the number too quick. I didn't get it, but I'm getting it now. Okay. So what are you going to talk to us about today?
So tonight I'm going to talk to you about how to prepare and protect a loved one in a medical crisis. So what we're talking about is a period of time where things can feel very much out of your control on many levels. And the tips that I can give regarding preparation for those times is organization and preparation ahead of time.
That's
Okay.
what I was going to say, that to
Yes,
prep before you
that's
are in
right.
crisis.
Just like any other crisis, whether it be a weather crisis or other crises, it's the same thing. So from an attorney standpoint, we're really concentrating on 3 different areas: making sure you're preparing the proper legal documentation you might need in a medical crisis, gathering the financial records and making sure that they are kept in a place that can be found easily. And then probably most intuitively, but what we tend to overlook is making sure personal information can be easily accessed and obtained by your family members. Okay.
What legal documents do we need?
So there are many legal documents that can be had, but there are some that are particularly important at times of crises. So we're looking at a set of documents that we would call advanced directives. Documents that give the ability for individuals to handle our matters for us when we might not be able to handle them for ourselves. The typical documents that would be prepared that would be classified as advanced directives would be a healthcare proxy, a living will, and a power of attorney. So I'm going to go over all of those. So a healthcare proxy.
But hold on.
Sure.
Tell me some. I'm the questions.
You got it.
Question, girl.
I'm the question girl. So before we go like very deep into that, what will be like you already told us the legal documents, and then what financial records, like very general, and what the personal information we should have?
So actually, I have long lists of that. So
that's good.
so you
like 3. We don't need the most important ones.
Financial documents is really organization. Do you know what your loved one owns? This can be very, very important in a medical crisis, because if we need to access this information when someone is severely ill, but maybe not close to death, there might be services that we need to get, that we need to have a very good idea of what that individual owns to determine how we're going to pay for those or access those services. So whether we have someone who needs to private pay for services, or whether we need to have someone who can qualify for Medicaid at some point.
And let me tell you, that's a big problem.
Yeah.
Because usually, like in my case, I don't know what my parents own.
Mm-hmm.
I have no clue. And if we are in crisis,
yes.
And it's very difficult to get them to tell you exactly what they own.
Yes, discussion of finances between generations is very difficult. It's a very difficult conversation to have. We can go into lots of reasons why that might be, but everybody has a reason in their particular relationships with their parents or grandparents or with their children that would prevent them from having that discussion. But it doesn't even have to be, in your face, here's everything you own. If your parents are well organized and that you know that in a crisis, you're going to go to this place and all the information is going to be kept in one place, that's great. But if your parents are not going to be organized like that and you have to take the bull by the horn, then that discussion, that very hard discussion, has to be had.
It is very hard.
It is. The idea that the children are going to be supervising the parent or the idea that the children might be supervising the parent as far as their finances is concerned is psychologically very difficult for seniors to really embrace. It's sort of like, when a person is no longer able to drive, or when they, may not be able to go to the grocery store by themselves. The same thing with finances. It's a very personal matter. We don't talk about finances out in the open. So having that discussion, really turns the tables as far as the parent and child relationship.
Yeah, it's like a taboo thing to talk about what they own, where the papers are.
Right.
I'm going through that, right? I
Right.
have no clue what they own, and they are,
Right. And each family is different. We try to emphasize the fact that when things are unknown, they can be lost. And once you kind of equate that to money, then people pay attention. Yeah. So, they work people work very, very hard for their money to save assets and to provide for their family. And any idea that those things might be in jeopardy can really sway the discussion and to really emphasize how important it is to have. But a sticky subject.
Okay. Yeah, I know. Yeah, that's another show in itself.
Yes.
What about personal information? What personal
So,
information should we have?
So lots and lots of personal information. And some of these things we take for granted. Knowing what the person's, loved one's full legal name is. I cannot tell you how many times I have had friends come into my office to prepare documents, and it turns out the name that they want to be called for their life is not their legal name.
No kidding.
And I never knew that. So
That's
what
funny.
their legal name might be, not the confirmation name that they really liked and used, but what's on their ID, what would be on their birth certificate, what needs to be placed on their death certificate, something along those lines. Social security numbers. Unless they've given you access to their copies of their tax returns, which would be something that you would want to have access to at the time. For the financial records, it would be a hard thing to find social security numbers, since we try not to put them on too many things because of identity theft. Birth date and place of birth. Birth certificates might be needed at some point in time, especially for women their names might be under a maiden name. It sometimes could be looking for a needle in a haystack, especially if you do not know where that person was born. Mm-hmm. Okay. So if you have a copy of a birth certificate, that's even better. And a copy is usually just fine. Names and addresses of relatives. It becomes very difficult when we have a situation where there might be a very small family structure or someone who is estranged from their family. Not knowing who they're related to is a little more common than people may think. So having that information of who to contact, copies of marriage certificates, death certificates for other loved ones, parents, spouses, possibly children, divorce decrees. Divorce decree is very difficult to get a hold of if you're not the person who is involved in the divorce. So if you're trying to get that information on behalf of someone, it does become very difficult in New York, especially. Same thing with adoption paperwork. If the individual is adopted or they have adopted children, very important to have that paperwork, because it's very difficult to reproduce or to find or get a hold of or access legally when the person may not be able to do it on their own. Military records, discharge forms. That's really, really important to have. Pension information, who do you contact? If you have questions regarding the pension, it comes into the bank every month. How do you get a hold of the retiree's pension office? Health and insurance information. Yes.
That's a lot of information to have.
Yes, exactly. This is, trying to keep track of your own can be difficult in some instances. Now, trying to add someone else's to your plate to assist them can be hard. Making sure you know where their insurance cards are, knowing what their prescription plans, vision plans, dental plans, and these days immunizations, very important. What kind of diagnoses does the individuals have? If you're going in to speak to a doctor, do you have information to make sure that doctor has all the information to make the most, the most the best medical care for that individual. Lists of doctors that they have. We no longer have a doctor. We have a fleet of doctors.
We have many doctors.
All treating different things. Phone numbers, can we get a hold of them at some point in time?
I have a question.
Yeah.
Hold on. First, hi, Dania. Hi, Marie. Hi, Joanne. That's it. Thank you. Parentheses.
So, the one of the things I learned in a class I went to from an attorney from your office last week was that everyone over the age of 18 should have a power of attorney.
Yes.
Which I thought was really interesting, which you never think of. If something happens, car accident, something, you can't get access to their information.
Yes. So as a parent of young adults, when my children turned 18 and they were ready to go to college, they all signed a power of attorney.
Why?
In case I ever had to speak on their behalf. So if once they're 18, they're an adult. So you have your own rights to handle your own matters, get your own information. If someone else wants to do it on your behalf, you either have to grant them permission to do so, or you have to have a guardian appointed. So a power of attorney is worth its weight in gold. If I had one of my children, if there was a medical emergency and I needed to, access their financial records in some kind, their insurance, the car insurance for a car accident or something else along those lines, I would need a power of attorney in order to do that. Yes.
Oh my God.
So that's for just anybody. So when I'm speaking to a senior and I'm whipping out the list of things that they should be taking care of, and the power of attorney is on that, and they are like, well, I guess I'm old enough to do a power of attorney. I'm like, if you're 18, you are old enough to do a power of attorney, and it really should be thought about.
So I know we're going like backwards, but we'll go back to your order. I'm sorry.
No, not at all. No, the power of attorney is really, really important to talk about. It's one of those advanced directives that we were speaking of.
But for example, for a wife and a husband, do you need a power of attorney as well?
Yes. So just because you are married does not give you the right to act on behalf of your spouse, as long as you don't tell my spouse that that's the case, because I make all the decisions. But
me too. But still,
yeah. So if you've ever tried to contact, the retirement system for your spouse, or a credit card, or God forbid your spouse should have the cable account in their name and you need to make a change, as long as your spouse can get on the phone and say, do whatever she wants, it's fine. But when your spouse is not able to do that for you and give permission, then a power of attorney is giving permission ahead of time for your trusted individual to handle any legal or financial matters for you. And sometimes it's not just about how do I handle the money? How do I sell the house? How do I deal with the retirement system? Sometimes it's information gathering. How do I get the statements to the bank account?
And we really don't think about that, until something really happens. So let's go back to your order.
Well, as far as personal information is concerned, I mean, it can get really down to the nitty gritty, who handles things on your behalf? Who's your accountant? Who's handling your tax returns every year? Who knows what they're supposed to be looking for and what you should be, what you should be including? Who's your financial advisor? And of course, who is your attorney? The trifecta of, the important people to make sure in an emergency you have access to: your attorney, your accountant, and your financial advisor. Other insurance, you want to make sure that your loved ones have access to other insurance information: your homeowner's insurance, your car insurance, life insurance, liability insurance. All of these things can be really important in a medical crisis. I always say, look, you probably also want to give your family the ability to contact the smaller providers in your life Who takes care of your car and does that? Who's the landscaper that comes every week to mow the lawn? Who are you supposed to be paying at that point in time? You know, who do you have to cancel if you need to cancel that service? You know, who do you need to the sprinkler system and things like that? I mean, if you're going to be really detailed, if a stranger came into your life and had to run it for you, what would they need to know on a day-to-day basis?
Yeah.
Mm-hmm.
Yeah.
But one of the most important things is username and passwords for your online accounts. Yeah.
Who knows that?
Mm-hmm. Right. So so the issue is you know, if the only access that an individual has to find out what it is you own when they need to is online access, because you don't get statements in the mail, then they're going to need those usernames and passwords. You know, how do they access your healthcare insurance information? You know, when you get those messages that a claim has been processed, they're not sending me paperwork any longer. It's going to be found online. How do they get into your phone? How do they get into your computer? You know, to get into your personal information? Yes. How would they handle mortgage payments? Let's say you make your mortgage payments automatically from your bank account. How would we access your mortgage account online? Because you're not getting a statement for that either. Social
Never
media.
thought about it.
Social media accounts.
Even with the husband, I don't even know a lot of stuff.
Yeah. So so that's really important. Do we know what your calendar is?
I think Marie was asking something.
She was asking about a letter of authorization to various agencies. I guess when you were talking about the power of attorney, would that work?
I'm gonna put a pin on that thought. We're going back to the power of attorney.
Yes. Well, we can actually go back to that now anyway. So, you know, when we talk about like what kind of personal information do you have to have available? You know, what do we do every day to access information and service providers for ourselves? And how much information is that we keep in our heads, that we just know that, you know, I call Steve when I need, you know, accounting work done, and my husband goes, "Who's Steve?" Really important. So, you know, and this is going to make it as easy as possible. You know, if there is a crisis going on, there are a lot of things that your family is going to be concerned about. How to get a hold of information and documentation should not be one of them. Okay. So that power of attorney can be really important, because if we need to have someone go to the bank and get information, or we need to contact a retirement system, or we have to contact the IRS, the New York State Tax Department, or something else along those lines, we're going to need to have permission from the individual in order to do those things. So that's what that power of attorney is. It's saying ahead of time, look, if I can't do this for myself, I want these people to handle my matters for me. And we want that power of attorney to be as broad as possible, so that we can handle anything that comes along. We don't want to be left out, because the only other option to a power of attorney for someone who's incapacitated is a guardianship proceeding. So this is going to the court to have someone declared incapacitated in need of a guardian, and appointing someone to be that person, who would then operate like an agent would under a power of attorney, gathering information, handling finances, except that now that individual is beholden to the court for the rest of the life of the incapacitated individual. And every time they want to do something, they're going to need to ask court permission for it. Some of the worst guardianships I've ever had to do is for spouses who are married more than 50 years. Nobody did a power of attorney. Now one is incapacitated. I have to get the other one appointed as the guardian. It's very difficult to explain how long and costly this process is, and how it really could have been avoided.
So it's better to have like the power of attorney than the other stuff.
Absolutely.
Okay.
Yeah.
Does it have like a due date, like for 30 years, for 20 years, or for a month, or for no?
It doesn't expire. Okay.
Okay.
Now, legal forms for the power of attorney change over time. The state sometimes updates the required form and how it's to be used. But as long as your form was valid when it was prepared, that power of attorney will be the agents that you name on it, your loved ones, your trusted individuals that you name on that power of attorney would be able to handle anything during your lifetime. So it's good until either one, I decide to revoke it and name somebody else. Okay, which does
okay. So that's my other question. How often do I have to update my power of attorney?
Well, you definitely
like if I get divorced and it's the husband
definitely.
there, or any other change?
Yeah, anytime that you need to make changes to the individuals you named, obviously you're going to need to do a new power of attorney. Sometimes it's because I may have named a sibling, and now my children are older, I want to name my children as my agents. It could be something, a good thing that, something. It could be because the individual you named has passed away. It could be because the individual you named is no longer somebody that you trust, or that is capable of handling that.
No longer in the life.
Yeah, and then if I prepare a power of attorney, when I die, that power of attorney dies with me. So no one is going to be able to operate from a legal or financial matters for me after death through that power of attorney. That's where wills and beneficiary designations and trusts take over. So we're going to talk about those also.
Okay. So I have I went to just a quick little story. I went to see a gentleman, and his wife is he wants to sell his house, and his wife has Alzheimer's in the nursing home, can't sign anything. He has a power of attorney, but it does not include the deed to the house.
Jeez.
So he has to get, from what I understand, a guardianship. And
so really important to have a very comprehensive power of attorney. The state puts out, this is the form that you're supposed to have to use. And then there are sections to add information and add powers for your agents. And it's really important to have as broad a power of attorney as possible in these situations where we want to have our loved ones handle things for us in a crisis. So this is not necessarily, I'm out of town and I'm not going to be around for the closing, and I want, Sally to do it for me. Right. It's one transaction. The power of attorney is going to be tailored toward that transaction. What we're talking about in planning is to say, look, we don't know what's going to happen. This power of attorney might be used for decades. Let's make sure that we can cram the kitchen sink in there so that if the need arises, the power is in there and the agent can act. Really important to have a good planning attorney that prepares a power of attorney.
I have another question.
Yes.
Of course you do.
No, but that wild thing came into my mind. What if I give someone, X person, the power of attorney? Can they do something without letting me know when they have the power of attorney? Of the power of attorney says that specifically when I'm super sick or I'm
okay. So the power of attorney is good as of the day it's signed. Okay. Legally, the agents that you name can handle things at your direction while you're competent or for your benefit while you're incapacitated. Okay. So when I have some seniors who think if I do a power of attorney, I'm giving up all rights to make my decision, which is not the case. Okay. If an individual does something against the principal's decisions, such as empty out their bank account, they may have some criminal issues against them at that point in time. That's theft, just like any other theft. It's sometimes this becomes a little tricky when we have someone who might be declining in mental capacity, who, it's clear that someone needs to take over. but it's difficult because the principal is protesting. I have the questions usually are, can my agent, act without my knowledge? Well, by definition, they're going to need to act without your knowledge, because if you're incapacitated, they're doing things without your knowledge.
Yeah. In the case I'm incapacitated, but in the case I'm not.
Yes. So the question is, do you trust the person you put on there? You must trust that person implicitly. And again, they could become, get themselves into more trouble than really what it's worth at that point in time. So they have to be very careful. There is
yes, they can do stuff.
Yes. So legally, no, they can't do stuff. Realistically, yes. If I wanted to rob a bank, no one is going to be able to stop me. Okay. Yeah. It's a crime, and I'm going to be punished for it at some point in time. But, and that's why people do bad things, is because we can't necessarily stop someone from doing something wrong ahead of time.
Mm-hmm.
Kathy wants to know, she has 2 adult children. Can both of them be named as power of attorney?
Yes. The answer is yes. You can name as many people as you want. I usually try to caution my clients that ruling by a committee is not necessarily the way to go. But if you have, 2 children, you can certainly put them both on as power of attorney. I typically find that there's usually one child who's going to do everything anyway. And the other one moves out of town, which is a typical situation. Having them both on. The issue is if they don't
agree, then
it can be very difficult. So, you just have to be careful. You just have to know who you have. If you have 2 kids, one makes all the rules and the other one follows along, you're still good. 2 that get along really well, great. They can split up the work at that point in time. Taking over for somebody's financial and legal matters in a crisis can be a very time-consuming issue. So having more than one person on is fine. You can also name alternates. So if your primary agents, if none of them are able to do it, you can have alternates on that would be able to take over in a worst-case scenario.
Okay, good to know.
Yeah. So the other documents that we would want to have prepared at the same time would be a healthcare proxy and a living will. So the healthcare proxy names a person to make medical decisions for you when you can't make them for yourself.
But then the power of attorney is for some things, and then the health proxy is for something different.
Healthcare proxy is only for medical decisions.
Okay. Mm-hmm.
Only for medical decisions, but they do sort of overlap. Remember that, deciding what medication to give you, if the doctor has a couple of options, is a medical decision. Okay. When it comes to, I need to talk to the insurance company about billing, that is a financial decision.
So the financial one goes to the power of attorney, and then the health one goes to the health proxy?
Healthcare proxy, right, which could be the same person. May not be. You may have people in your life that would be able to handle financial and legal matters, but would crumble in a medical situation, or vice versa. So that you can always make some personal decisions about who should be doing what. Okay. A power of attorney specifically cannot have powers regarding making healthcare decisions. It has to be 2 separate documents.
And with the health proxy, it's the same thing. Once you're 18, then I need a health proxy?
Yes. In New York, we have something called the Family Care Decisions Act. So if you don't have a healthcare proxy, New York State has a list of individuals that could make some medical decisions for you. And it starts off with, you're sort of in the order of your closest blood relatives, your spouse, your partner, your children, your parents, your grandchildren. And then the last one is anyone interested in your welfare. And I always think, gosh, anybody could walk off the street and tell somebody they're interested in their welfare. That doesn't really make much sense. A healthcare proxy is by far a much better option. The other thing is that the agent on the healthcare proxy can make decisions along the entire continuum of care. So it could be something temporary. Somebody could be temporarily unconscious. They could be under anesthesia. It could be, flipping out from the pain medication and hallucinating at that point in time, whatever it might be. It could be something long-term. For older clients, maybe dementia or stroke might be a long-term issue to cause someone to need to make medical decisions for you, but maybe not life-threatening at that point in time. And then it's also for end-of-life decisions when the doctors determine that there's nothing, that they've exhausted all medical options and the dying process is firmly in place and dying is imminent. The making decisions along those lines, you have to have certain information in your documents. So having that healthcare proxy, and then the living will talks about what your wishes would be for those end of life decisions.
Okay. So you need to have both to make those decisions?
Yeah, you should have both. They're separate. The healthcare proxy names the person. The living will talks about what your wishes would be for those end stage decisions.
Got
okay.
it.
So the three of those together, the power of attorney, the healthcare proxy, and the living will, that really makes up what we call advanced directives in the legal field.
Yeah, because the other way, then who makes the decisions?
Right.
The spouse, if they don't have a health proxy, who makes the decisions? The spouse, the mother,
So prior to having the Family Care Decisions Act in New York, it used to be the doctor, whoever the attending physician was, which was a little scary, because they don't know they don't know you at all.
Exactly.
So it could be the issue is when there is differing opinions in the family. The doctors are going to be very hesitant about doing certain things, even if that's what you wanted, because you've got family members, fighting over things. And then you may end up having to get a declaration from a judge, which is this whole point of these
delays stuff.
The whole point of these advanced directives is to try to make it as easy as possible on your family, to name those people you want to do things so that they can get what they're in charge of done. And so that you can keep as much peace as possible amongst any family that might not be on board, and not have to deal with going to court for any reason at that point in time.
The other question is, how do I keep those legal documents? Do I have it in my computer? Do I give it to the person? Do I go to the lawyer?
So typically, I would suggest to you that when we prepare those documents from our clients, those advanced directives, we give the originals, and you can sign more than one original of those documents, the healthcare proxy, living will, and power of attorney. You can sign more than one. So we provide, 2 copies, 2 originals signed to the clients. We make sure that we keep a scanned copy in our records. I have had to fax healthcare proxies to hospitals for some of my clients who they can't put their hands on it when they need it. Important to make sure photocopies are given to the individuals that you've named, or that the individual, that where to find it in an emergency. This is the box. It has all my information in it. If the paperwork is easily found, that's just as good. Okay. Truly, the most emergency documents is that healthcare proxy and living will. Photocopies are accepted at all times. So
or on my phone.
Or on your phone. Yes, exactly. Being able to.
But then they need the password to get into your phone.
But then if they give it to me, I have it in my phone. I don't need their password.
Exactly. So if a senior comes in and they've named their 3 children on their healthcare proxy, in order, then, I always suggest to them that they are going to want to give photocopies of that document. That's, they're going to be the ones called at 3:00 in the morning, and they're not going to be able to get a hold of our office to send a copy in until business hours. It's really important. Power of attorney, it's dealing with financial and legal matters. You can't get into the bank until you can call me in the morning anyway. So
yeah, that's true.
Yes.
So I had something else on my mind, but I forgot.
So I keep all the wills and deeds and things and marriage and birth and the death. I have my parents' death certificates in the safe.
Yes.
And I told my daughters, said, you know, I have the safe. And I guess apparently I had shown one daughter where the key was, and I didn't show the other daughter where the key. She says, "You never told me that." I said, "Oh, well, now you know." So you got to make sure that everybody knows.
Yeah. Important to keep these documents in a fireproof vessel of some kind. Okay. Fire and waterproof for many of us on Long Island would be preferable. You should not be keeping these documents in a safe deposit box at the bank. If any one of the signatories on that box is deceased and the bank knows, the box is sealed and you couldn't get into it anyway. The bank is not typically does not have a lot of liability for loss of property within your box. There was an incident probably at least a dozen years ago on Long Island where there was a fire at a bank during business hours, and the staff rushed out, but the person in charge of closing the vault did not do so. So there was a lot of loss of information to water damage, not necessarily fire damage, because they did put the fire out, but to water damage to the items in the vault at the bank. So, I usually say, the safe deposit box is sort of an outmoded way of keeping things safe from the elements, fire and water. So, and you can probably do a better job keeping track of your personal items than the bank can.
Oh, what's the other legal document?
Okay, so the other things
now that we're in legal documents.
Yes, other things that we would talk about is what you would need regarding financial transactions after someone passes away. So we're talking about a will. Should everybody have a will? The answer is yes. Does everybody need to use a will when someone passes away? The answer is no. It's there because we may need to use it and we may not. There are other ways of transferring assets, beneficiary designations on bank accounts, life insurance policies, annuities, IRAs, 401ks. Those assets would go directly to those individuals named as beneficiaries as soon as they could present a death certificate. But a will is there for those things that we can't transfer because of that. So, it may be a piece of real estate. You aren't going to put your children on as owners on your real estate. You can't put a beneficiary on real estate. So your will may need to be used to transfer real estate. There may be reasons why we want to use a will in order to transfer assets. If the assets are going to minors, we want to make sure that their money is held in trust for them with an appropriate person in charge of that. You get to make all of those decisions in your will, so that if someone passes away and they're leaving something to minors, that it doesn't get held by the court until they turn 18. That we have a mechanism in place that we're going to handle that outside of the court system.
Grandparents, if they want to leave something to the grandchildren.
Parents. Or parents, right. Exactly. Parents that are skipping their kids and giving everything to the grandkids. There could be lots of reasons why that is done. There's also trusts. So people are a little confused when they come in. Trust is kind of a scary, unknowable item out there. It's just another way of owning assets. Trust can be done for as many reasons as there are stars in the sky. So it could be a trust is needed just to transfer assets when someone passes away. Skip having to use that will for the real estate. Have a trust own the real estate. Will it go easier to the kids later on? The answer could be yes. Trusts are used for saving on estate taxes. If we have a taxable estate in New York right now, that would have to be over $6 million. Then we might want to set up trust for tax savings. We would want to do an irrevocable trust for protecting assets from long-term care. If the worst case crisis, the medical crisis happens and someone needs to spend time in a nursing facility, how do we protect the assets from being lost to the costs of nursing home at that point in time? We would want to make sure that we're talking about trust for all of our seniors that come in. for that kind of planning. There could be trusts in place to own life insurance to reduce a taxable estate. So there could be many, many reasons why a trust is done. So as far as what happens to assets after you pass away, we have the will, we have trusts, we have beneficiary designations. There is a plan for everyone, but everyone's plan is not the same. Okay,
Exactly.
so important to know what your goals are. We figured this out together. Okay.
Yeah, because it's
What
the
the
same,
client's
like,
goals are. Yeah. What might keep them up at night. Maybe some of those things I can alleviate. Maybe I can give them more things to keep them up at night, or try to take more off their plate. And then what the plan is in order to make sure that we're planning for those worst case scenarios.
yeah,
So,
because usually you hear other people's stories and then you go, oh, my aunt did that, my grandma. Yeah, but that's your grandma. It's not you. You have different
yes,
situations, you have different assets, and you have
yes,
different goals than your grandma, my neighbor, or whatever.
exactly, exactly.
I always say the same, but that's true. I have calls like, oh, my neighbor. Yeah, but that's your neighbor. That's not
Yes.
you.
Yes, exactly. I have lots of clients that come in. My neighbor said this, my, relative said this. I had one that came in and said, so my butcher said, I'm like, just stop right
Your
there.
butcher.
That's
Wow.
going to be a tip on a good cut of meat. We're going to end that conversation there. So,
Kathy has a question. Should husband and wife have individual trust or joint?
it depends on the situation. So usually for a taxable estate, definitely separate trusts. If second marriages, second trusts are usually what is chosen. For seniors, sometimes depending on what assets are owned, what the ages of the seniors are, and what their health concerns are, sometimes we need more than one trust in that case. So it really just depends on the situation. There are many factors that have to be involved in whether or not joint trust or separate trust should be used.
I have another question.
Of course.
Of course I do. I have to have like a lot of stuff, like a lot of money, like a lot of properties to have a trust or a will?
No. So the unfortunate issue with long-term care planning, or that nursing home planning and preservation of assets, is that the smaller your estate, the faster you can lose everything.
Mm-hmm.
So very important to understand but you want to make sure you're getting value for what you're looking at. What does this plan entail, and what is it doing for me? So that's really important to determine. What is the goal? What is the goal? Is the goal to make sure that your kids have something when you pass away? Are we concerned with the things in life that should be concerning us? The cost of care, by far, is the big elephant in the room for seniors. It can
Yes.
be financially devastating to a family. We want to make sure that we're making the best plan we can for our clients, so that their goal can be reached in as much as possible. So the size of the estate doesn't really matter. It's, what can we do to make sure that gets passed on?
Yeah, because sometimes we have these ideas, or that, oh, I don't have that many assets, why should I do and plan anything?
Right.
Oh, I'm
Right.
not that rich. Oh, I don't have that. That's for rich people, for example.
Right.
Or
Right.
I don't need it because I have very few things,
Right.
and we don't plan ahead of anything.
Sure. In New York, for an estate tax situation for a family, we'd be having this discussion when somebody's reaching $4.5, $5 million, $6 million. And people always say, oh, I wish I had that. That's great. So that's one set of problems. But, for estates that are under that, we have other sets of problems. So should we be avoiding using a will so that we don't have to go to court and have it probated when somebody passes away? There are reasons to avoid that situation. That might be the goal that you have, and after discussion, and we can certainly arrange that. That doesn't make any difference how much you own at that point in time.
So Kathy has a question that if your assets are under $1 million, your estate doesn't go to probate? Question mark.
No,
that's not true, right?
Probate has nothing to do. A probate is the validation of the will by the court and the appointing of the executor. A probate is needed when there is an asset in the deceased person's name that we cannot tell from the asset itself who it belongs to after death. So something that does not have a joint owner, something that does not have a named beneficiary, something that is not owned by a trust. There is no asset level as to whether or not the will has to be probated. The question is, are there any assets that we need the will to govern?
So like I've had cases in real estate where the mom passed and nobody else is on the deed. So they had to go to probate, and then the children were able to sell it.
Correct. And, frankly speaking, so then I have clients come in and say, I just want to add my kids to the deed. And that's a whole other issue, because now you've got, liability issues. You lose your tax exemptions. You can't, deduct your expenses on your income tax return. And the kids are going to be very angry when you pass away, because they're going to have to pay capital gains tax on the sale of that house, where they wouldn't if you hadn't added them on. So there's many reasons why we would want to have a discussion. There are better ways of doing that. We could actually create a trust to house that house so that it would be easier to transfer. We wouldn't have to probate the will for that house when you pass away. The trust is a self-settling document, so it doesn't require any court intervention. And the trustee could then just handle the house at that point in time.
And do the trustees of a trust have to pay capital gains on what they get?
So the trustees don't pay. They're just your trusted person who ends up doing a lot of work for a very little pay. Okay. But the beneficiaries, depending on how the trust is designed, they would, many times those beneficiaries are going to get a step up in basis. That's just the technical tax term for it, where the capital gains is going to not have to be realized upon death. And they be able to get all those tax advantages of inheriting the property, even through a trust.
Kathy wants to know, so you need a will.
Everyone, yes.
Not necessary to have a trust.
So again, this is all about what are you trying to do? Okay. And
what are your goals?
Now I'm scratching my head.
When we have a new client come in, we sit down with them for about 2 hours. We want to know everything about their finances and their family. Which is really behooves them to tell me all of those things, because then we talk about, what are your concerns? What are we doing here? What can I tell you about what I'm concerned with looking at this as an attorney from the outside? And then what are your options for resolving those? And one could be preparation of trusts. If you want to preserve assets from long-term care, from a nursing home or home care, so that we can access services through the Medicaid system, you have to have a trust in order to do that at this point in time. So really important to make sure that you're discussing your personal situation. So I can't tell you that if the amount of money you own, says that you should have a trust or not. That's not a thing. Does everybody need a will? Yes, everybody should have a will. Do we want to use the will after somebody passes away? Not always. We want it there just in case. Just in case there's something that's out there that we didn't know about or didn't get put in the trust, or, we couldn't take care of until after you died, then we want to know who it's supposed to go to. You have to make sure we have that backup plan.
What do I put in a will?
Well,
what qualifies for a will?
So a will is just a document. So there's decisions you need to make in the will. You need to know who's going to be in charge of your estate when you pass away. That's called the executor. You're going to want to know, who you want to leave your assets to. Those are the beneficiaries. If you have young children, it's a place where you can designate who you want to have the guardian of your children to be. It's where we can set up trusts for disabled beneficiaries. If you have a disabled child or a grandchild, very, very important that assets don't get left to them directly, that they be put in trust for them. And also for minors. And when I talk about minors, a minor is technically anybody under the age of 18. But when you talk to an attorney about estate planning, should it be 25? Should it be 30? That's really a discussion that we have to determine what your comfort level is as far as when the young individuals, the young beneficiaries in your life should be handling their own finances.
So you can put that age. You can say, oh, until my son it's 25.
Yeah,
because he's a little crazy right now or something.
It doesn't make any difference. I try to tell my clients, look, I'm uncomfortable with anything under the age of 25 anymore. I think 25 is really the new 18 when it comes to financial maturity. Let's not have a discussion of anything under 25. So, it can only benefit the beneficiary. What you're really trying to do is to protect that individual, A, from their own inexperience, or as like my clients like to say, from their own stupidity. And second, to get to a maturity level where they can maybe spot people who are trying to take advantage of them, which, doesn't necessarily come at the age of 18.
Yeah, that's true.
Kathy says I think I'll get everything: a will, a trust, power of attorney, and now I need a drink.
Very good, Kathy. We were talking about this before the program. I like to say I'm one step up from the dentist. I don't cause any physical pain, but people do dread coming to an attorney sometimes, making that appointment, talking about what would happen if I passed away or became incapacitated. I mean, you don't want to think about that. But making sure you take the bull by the horns and do this is invaluable to your family. And everybody feels better when they finish.
Yep.
If there's one thing I should do to start, what is the one thing?
What one thing should you do to start? Well, I think you should actually talk to an attorney regarding your personal situation. We do free consultations for new clients where we have them fill out an intake form. We sit down, we hash out what we think they should be concentrating on. They can then make some decisions and they can move forward. And if the only thing I get out of that is I impart some education on the individual, my job is done at that point in time, because they're going to know what they're going to need to do and do it at an appropriate time.
We have one.
No, Jean said pre-plan your funeral.
Mm-hmm.
And I know
where do I put that? In the will, in the trust?
No, actually, so when you pre-plan a funeral, you actually do that with the funeral home.
Oh, okay.
I have lots and lots of clients who ask me if pre-planning their funeral is a good idea.
My father is already pre-planning his funeral. He said, "Oh, I'm doing this and this," and I said, "Okay, put everything down what you want, and that's what we'll do."
Mm-hmm. So you could actually go to the funeral home. You can plan the funeral and or pay for it.
he already paid for it
over time. The funeral industry is very highly regulated, so this is not something where you're going to lose your money over. So there are two things that I think are really important when it comes to pre-planning your funeral. One, the big benefit that I see that comes out of it is that you're really taking this burden off of your children. A funeral has to be planned in a very short period of time. That can be very difficult at times of high emotions, and not having that taken care of is a gift to your children at that point in time. And the second thing is that you're probably going to spend less money on it, because just like anything else, in a period of high emotions and anxiety, you're bound to overspend.
Yep.
Well, do we have comments, Denise? Questions?
We got comments here. We had a lot of people on the show. This is great. Joanne.
Hi, everybody.
Joanne says it's bittersweet, sad, but you're glad your wishes are documented. Everyone needs to do this. Sue said she did that for her mom. I know my sister-in-law did that for my mother-in-law. She was ill, so she had everything set.
Yep.
So it was very easy.
Yep.
Yep. So yeah, it's a good idea.
Yep.
All right. I mean, I told you that we would be talking for half an hour to 45 minutes, and we're at an hour already.
Yeah.
So, and a lot of people, I appreciate everybody coming on, and I hope you're getting a lot of good information. So,
do we have time for just one question or two, or not? Or
Yeah,
no
sure.
questions?
what?
No. Whatever you need.
No questions anyway.
No questions from Sandra, okay?
I'm sorry, but I have a lot of questions.
That's okay. That's okay. We like clients with questions because
Sometimes
that means,
I don't have questions.
it means they're
Anybody out there have a question? Sandra, why don't you put up that information again?
Which one? Oh, I'm like, which one? This one?
Yep.
yes.
Yep.
Try to
So
make
if you can't read that, it says,
let me try to make it bigger.
So it does have my direct email address on it
It's right
and
there.
our phone number.
okay, good.
Okay.
If you have questions or you want a free consultation,
Absolutely.
reach
We're
out.
always available for questions.
That's the first
Great.
thing you should do, remember.
Kathy said excellent information. Thank you so much. Kelly said thank you. Anybody else have questions? Joanne said great information.
Christine,
Anything
something
else?
we forgot to ask.
Yes.
Yes.
No, I think we covered everything that I wanted to cover and
Perfect.
more tonight. So, I mean, I could talk for hours, but
Yeah,
on
Me too.
many different
Me too.
That's true. Yeah. Yeah. So that was great. Thank you so much, Christine.
Sure.
Mm-hmm.
We're glad you can come on, give us all this great information. I made a list. I got a lot of things to do.
Me too.
Yes. Yep.
So
Yep.
remind us of your phone number.
Okay, so our phone number is 631-979-4300.
Jean, my notes. I don't know if you can see them. She's asking if I took notes. Yes.
Good. I'm glad everyone took notes.
Denise, where can they find you?
Wait, what's your email? I'll put that in the chat too.
Yeah, put it on the chat.
So it's C Schiebler. That's CSHIE.
That's the phone number.
BLER at Trusted Attorneys. So TRUSTED attorneys with an S.com.
Okay, I think I got it. Okay,
Sure.
That's great. Thank you.
Denise, what's for next week? A surprise?
What's for next week?
A surprise.
Jean wants to know approximate charges for all this, just a ballpark.
Oh, so it's everybody is so different. It's really, really tough. I can tell you, for if a single younger individual is coming in to do a will, a healthcare proxy, living will, and power of attorney, it's $1,500, and all the way up to many thousands, depending on what the needs are. So it's really great for you to find out ahead of time and know what your options are and what those options would cost.
Mm-hmm.
Oh, the email address is a little off. It's attorneys is ATTORNEYS.
So they're off.
Say it again.
Attorneys is NEYS at the end.
Oh, NEYS. Oh, okay. Okay. All right.
So write it down. Where can they find you? Denise.
Me?
Yes.
I'm concentrating on writing this.
Well, I'm going to tell you where can you find me there. You can find me on Instagram, Facebook, and YouTube, and TikTok, and everywhere as Sandra Roman Real Estate. And remember, we're live. This is our second event of the season number 4. Next week, who are we having, Denise?
So next week we have Megan Shergill, I think I'm saying her name right. She works for community care, home health care, and she is an expert on caring for your loved ones. So she's going to talk about how you can use Medicare to care for your loved one at home.
Very good topic.
And get paid. So it's a good topic, and she's a great speaker. And so we're going to have her next week. And the week after that, for our Valentine's episode, we're going to have our very own Lily McCarry on with a friend of hers, and they're going to talk about love after 50.
So everybody that it's 50, come over. And if you're not, come over.
So that's going to be fun as well. So everybody is saying thank you and great job.
No, thank you, says Jean. No,
thank you.
After,
you don't want love after 50, Jean. Yeah. So we're going to have some great couple of weeks coming up, and we hope everyone will join us. And thanks again, Christine.
Thank you for having me.
Okay.
Besos.
Good night.
Bye-bye.
Jean says once and done.